Lordship, may I take my lord, small typographical errors. Appellate side, my lord.
Appellate side.
I have marked my lord, pencil.
We'll show it in the case list.
Mr. Soft, learned friend also present.
Yes.
My lord, I may be allowed to mention one matter for assignment, my lord. This is a matter.
Just give that letter to the OSD.
This is a little mention has to be made, some submission, because my lord, this is a matter related to ED, enforcement director. One criminal matter was going on before Justice Shubhra Ghosh for bail application, my lord. But during the hearing, it was pointed out this is a Ponzi matter arising out of a Ponzi matter. ED had conducted.
Justice Ghosh has released it, saying
he has released it because it is not in her jurisdiction, my lord. But one thing is that the matter has been heard expeditiously and on many occasions.
May I just speak my lord's
Justice Shubhra Ghosh. Justice Shubhra Ghosh was hearing this matter, my lord. It was the bail application was filed before her, and then it was.
No, I think Wednesday. When did you give this letter?
My lord, today itself I have served it to. Yesterday it was released by my lord.
Oh, yesterday.
Yes,
Then you do one thing. You give the letter to the OSD.
Yes,
Mr. Samrat Gupta. I'll do it today.
My lord, our only prayer is that since the matter was heard on many occasions before Justice Shubhra Ghosh.
You give the letter, madam. You don't tell what I have to do.
Well, deeply obliged, madam.
Yes, madam. Any mentioning?
She was my counsel.
I was with my learned friend. I was making the same request.
Delhi.
You are not audible, madam. Madam Rotagi Mota.
Am I audible to my lords? Yes, my lords, am I audible?
Now you are audible.
My lords,
Yes,
I'm deeply obliged. My lords, I was making the similar request with which my learned friend was making. But my lords has already.
I'll do it today. I've asked your colleague to hand over the letter to the officer on special duty. He will call for the file. I'll do it today.
May I just add one sentence to the mentioning, because I've heard my lords. My lords may just bear in mind that this person who is seeking bail has been in custody since November, my lords, and detailed hearings have taken place. Then I leave it to my lords.
Okay.
Deeply obliged.
Noted. Thank you.
Lordship, I want to mention one matter for rectification of the order.
What happened?
There is
What mistake? Original side, appellate side.
It is a.
The round on which the review application has been filed is that one person. Yes, it will be shown in days list. Correction if
But only my name may be included.
we'll put it in capital letters. Today at 2 p.m. they will show it. Yes, sir.
My highest respect and the deepest respect, I should say that highest respect for the bench and the deepest respect for my lords.
Thank you.
And only one thing, this is out of my enthusiastic effort. I say that one matter your lordship will recall that in a matter, my lord, where a judicial person working in a group D post, certain directions were passed. Then in the contempt, your lordship passed consequential directions. That has been done.
Complied.
And acted.
Very good.
My lord, by
He's happy.
yes, my lord, I have the highest respect and the deepest.
Thank you very much. Yes.
Original side daily list item number 1, new application tax matters.
How many days?
595 days. My last order is there.
229 days.
Perhaps there is a wrong calculation by the by the stamp vendor, because the order has been received.
My lord, may take a look at page 2, my lord. My lord, the order has been received on 5/9/2023 and it has been filed on 20 August 2025. So, my lord, it is all 595 days. My lord, this is the last order.
Where are you reading?
My lord, I am reading page 2, my lord, of the opposition of the delay petition. My lord, page 2.2, my lord.
Hmm. 5/9/2024.
My lord, this will be 23.
Malad, that should be Malad 2023.
23, my lord, appeal for time limit was on 2/1/2024. Time limit to file appeal expired. My lord, they filed it on 28/2025.
So there will be 500.
595 days, my lord. Last day, my lord, had done the.
Sir, please come.
My lord, this-
This appeal has been filed by the revenue under section 260 capital A of the Income Tax Act 1961 within bracket the Act, challenging the order dated 21/8/2023 passed by the Income Tax Appellate Tribunal B Bench Calcutta within bracket Tribunal in ITA number 643/KOL/2023 for the assessment year 2015-16. There is a delay in filing the appeal. The department has computed the delay at 229 days. It is pointed out by the learned advocate appearing for the respondent. There is an error in calculation since the date on which the order was received by the department, the date on which the impugned order passed by the tribunal was received by the department has been wrongly noted as 5/9/2024, whereas the correct date is 5/9/2023. And if the said date is reckoned, there is a delay of 595 days. We have perused the affidavit filed in support of the application, and if we find no acceptable reasons for the inordinate delay, and as the delay remains unexplained, we are not persuaded to exercise any discretion in favor of the appellant department. In another appeal relating to the very same assessee, in ITAT 169 of 2025, there was also a delay of 595 days, and the same was and the prayer for continuation of delay was rejected by order dated 10th September 2025. For the above reasons, since the delay has not been explained, the same cannot be controlled. Accordingly, application in GA number 1 of 2025 is dismissed. Consequently, the appeal stands rejected.
I can know 1 to the
1 and 2 same.
same.
My lord, only the year will change. Assessment year will change.
Only the assessment year will change. Yes. Here correctly they are computed. Here correctly they are computed. So that para you can omit.
Malad, only Malad, your lordship will not allow me to give 1 minute time. Malad, with the leave of her ladyship, Malad, may I say something? Because Malad, today perhaps the sad day. Because Malad, since Malad 2019, Malad, we are happening before the lordship. And I can remember the days that when I'm junior standing counsel doing the income tax matter, my lord, I have nothing to submit because I do not know the subject. Only your lordship in court, sitting court number 16, said us, you only praise the facts. I will take care of the law points. And initial days, my lord, we faced difficulties before the land is single judges. But due to such encouragement by your lordship, now Lord, what we have now, only blessing of your lordship. Very sad.
My lord, we were having a word, my lord. Since 2 days, my lord, we are not being able to do any draft, my lord. We are not being able to concentrate.
No.
My lord.
The judges, I mean, as I said the other day also, judges retire, but advocates don't retire.
My lord, I was telling my
No, Lord, we can assure one thing, Lord. The relationship between the judges and the advocates today, my lord, may going to be an end, my lord, but the relation between the teacher and student, my lord, remain, my lord, it will, my lord, go on, my lord.
And I was telling my junior that my lord has bear with us for so long, and my lord, being such a junior counsel, my lord has given us the opportunity. My
Yes, yes, everybody is doing well.
lord, we remain indebted to my lord, for giving us this opportunity. My lord.
Thank you.
Yes, yes.
Lordship, may I permit to mention one matter for correction of the order, Lordship. Order
You are mentioning upon notice.
Lordship. No, notice was not served, Lordship. Lordship, at the time of pronouncement of judgment, your Lordship mentioned that the compliance of the order will be within 12 weeks. That was missing, Lordship, in the order. Paragraph number 3, Lordship.
Para number 3.
Lordship.
So we dictated that, is it?
Lordship, Lordship. Recording is there, Lordship.
And who appeared? Mr. Chatterjee.
Niyatpur Chatterjee.
Lordship, I was also there, but my
It's
name is not there.
That also we'll include.
Much obliged.
The matter has been listed under the caption to be mentioned. It is pointed out by the learned advocate appearing for the applicant that when the court passed the order on 3/9/2025, a time limit was fixed for compliance of the direction, directing the authority to comply the order within a period of 12 weeks from the date of receipt of the server copy of this order. However, due to oversight, this line does not find place in the order dated 3/9/2025. Accordingly, in the after paragraph 3, the following paragraph shall be added as paragraph number 4. The above direction shall be complied with by the concerned authority within a period of 12 weeks from the date of receipt of the server copy of this order. Full stop. Further, the name of Mr. So-and-so, learned government counsel, be shown in the order dated 3/9/2025, and this order shall form part of the order dated 3/9/2025.
Get put, your Lordship. Get put.
Appellate side, daily list, serial number 1, 2, 3.
Lordship, before my learned friends begins, Lordship, may I just say that my clients are so eternally grateful to your Lordship for having intervened. Lordship, they've got small token of pictures painted by these two.
Oh, lovely.
Lordship, I'd like to give your Lordship's Miss
Oh, thank you.
Lordship would see they are so talented. They've done doodle art and one has done a watercolor. They wanted to give them to your Lordship as a great appreciation of what your Lordships have done.
Beautiful.
They cannot even raise their hands.
Ah.
But still they have made this.
For ladyship also I can give.
Yes, I have 2 for each of you. Of course. That is the reason I handed over 4.
But it's a valuable goods.
Huh?
The most valuable goods in our eternal life.
And it's my privilege to be a part of this patient. It is our privilege too that we have got your Lordships. Another good thing that I would like to show you, Lordship, these 2 pictures.
You keep it here and then send it to her.
These 2 pictures your Lordship will see pursuant to your Lordship's direction on the last occasion. These
on 7th September.
7th September, the wheelchairs were given to 11 persons. So there were 7 of them here and 3 have been given. The patients could not come themselves. It has been given to their guardians.
So nice.
So all this has happened during your Lordship's regime and we cannot but say how.
No, we'll treat this as part of the order, this photograph.
Lordships. Lordship, I,
Then what if Mr. Mukherjee?
Lordship, I have made your last occasion, your Lordship, I directed a compilation of orders.
Of the order passed by your Lordship.
This will be, I mean, this is a compilation which will help any bench because all the orders have been given.
Now,
Kindly see,
the DME has also given one. Also here. They have given one.
Lordship, we are so glad to have the Advocate General also today.
No, I take this last opportunity to appear before this bench.
Probably Monday we will give you one more opportunity.
Please.
Now, they have given a chart.
Yes.
Why don't you examine this chart?
Lordship, I will,
Mr.
Let her come back on Monday.
We'll see. Monday we'll have this.
Lordship.
Sleep study, 2 machines you have purchased, 35 lakhs rupees each.
That is so good. Lordship.
Sleep study machine, 35 lakhs each. We have purchased 2 machines.
Very nice.
Lordship's
Thank you.
anguish on the last occasion has had a very deep
today-
effect.
No, show from this.
Yes. Kindly see right hand side.
One day to 2 day
Three.
complied with. 3 specialist medical officers have been detailed at IPGMRs. Copy of the order annex. 2 sleep study equipments
this
are
one.
available.
This one.
So with the Institute of Psychiatry, in case additional machines are required for the work, such additional machine would be provided by the department. Then 5,000 rupees
Yes.
issue involves policy decision, hence the matter is being placed before the learned Advocate General.
General has taken over the matter.
He will take care of that. Then information relating to UDID and disabilities are attached separately, Annexure 3. Very good. Information. Then 50-bedded critical care block is on the verge of completion at the KPH and would start functioning in 2 months. 5 ICU, CCU beds would be earmarked at this CCB for rare disease patients. So that 5,000 rupees stipend, AG is there, don't worry, it will happen. Then UDID, Annexure 3, you please take and you examine this and come back on Monday.
Lordship.
We have heard so and so. The Advocate General. It is heartening to note that the government, particularly the Health and Family Welfare Department, have been proactive to the orders which were passed by this court from time to time. And
Lordship, the gist has been given. Lordship kindly goes through the list of orders. I've given the gist of the order of the last date.
From time to time. And the Director of Medical Education, Government of West Bengal, has submitted a report dated 12/9/2025 within bracket, which is taken on record, with regard to the action taken by the Department of Health and Family Welfare with regards to the various directions issued in the order dated 28/8/2025. We are happy and pleased to note that the Department of Health and Family Welfare had taken expeditious steps to comply with the directions, and the action taken has been given in a tabulated format, and for better appreciation, the same is quoted here under. You give a soft copy of this tabulated.
Yes.
No, you give a soft copy.
Yes.
Also, a tabulated copy of this report be served upon the Union of India so that.
Yes, Mr. Mukherjee will give.
So, with respect of the UDID, if there is any anomalies between both
You go through it. Sir, you please.
We will supply.
And if you can give a soft copy to our
Yes.
assistant registrars, they will incorporate the entire tab. Full stop. Thus, it could be seen that most of the directions have been complied with. And with regard to the UDID and disability certificate, in the report of the Director of Medical Education, a report prepared by ADHS-SBHI/Mental Health and State Coordinator-UDID, Department of Health and Family Welfare, Government of West Bengal, has been annexed, dated 9th September 2025, has been annexed. We direct the learned advocates appearing for the petitioners to go through the said annexure and make and if any further clarification is required, the same can be placed before this court on the next hearing date. Ms. Nandini Mitro, learned advocate appearing for the petitioner in WPAP 20 of 2020, has submitted that that wheelchairs have been purchased, and on September 7, 2025, the wheelchair have been handed over to the children, and a photograph in this regard has been placed before this court, which shall be taken on record. Full stop. The learned advocate for the petitioner has also prepared a tabulated statement captioned bullet points
of the orders. Actually, it
which
should
contains the date of the various orders passed by this court and the directions given from time to time, so that to assist this court. This this is also taken on record. The learned advocate for the petitioner shall keep updating the bullet points as and when directions are issued. So UDID, if we clear it,
UDID might not only one submission. If the card be made universal, because
you
whenever
use the mic so that everybody will be here.
Basically, what she's saying is that the card should be made on an all India basis. What has happened with some of our patients is that when they have traveled to any other state, that particular state has not accepted card given by West Bengal. So we are basically wanting an all India basis card.
No, madam is here.
Yes, that's why when madam is here, work gets done.
But madam is this head of the
Neonatal.
Neonatology.
Yes. So the UDID card will not be handled by her.
We also record the presence of Professor Dr. Suchendra Mukherjee, Head of Department of Neonatology, Nodal Officer, CEO of Rare Disease, IPGME and R, SSKM Hospital, Kolkata, and the court conveys deep sense of appreciation to the learned professor.
Petitioner reply.
See, you go through whatever they have given now, discuss with your senior, and then you can inform Mr. Mukherjee what are the further directions or clarification you require.
Fine.
We can sort it out.
Great.
And if that 5,000 can be
5,000. That would be very useful to these
so
patients.
list on Monday.
I'm grateful to you, Lord.
Mostly we do not I will not get the chance.
Monday we will not leave you, Mr. Monday we will take care of you.
Lordship, we are also deeply appreciative of Professor Mukherjee coming. Whenever she comes, work gets done.
Definitely, 100%. So you should, in fact, if you organize some function or something, you please invite her.
Please invite her, but she doesn't come.
No, now she will accept. Next Monday, we will pass an order saying that professor will accept invitation. But the function should be commensurate to her position.
Yes.
Like 10 people are there, you invite her.
There were, I understand I was unwell, I could not go, but there were 70 people this time. So they are very hopeful that it will rise.
Now, what you can do is, you do one thing, you in your society letter pad, you make a proposal and address it to Justice Shampa Sharkar. She is the chairman of the Juvenile Justice Committee.
Okay.
Technically, it may not fall, but recently I'm on, that is tomorrow, there is going to be a statewide consultation in which, though disability is not one of the topic, I have requested one resource person to be invited. He is the chief officer of India Autism Center in Kolkata. If you come the Ma flyover, you'll be able to see on the left side. They are coming up with a very big facility in Diamond Harbour on the main road. What is that? Swaminarayan Temple, no?
Yes, Swaminarayan Temple.
Little beyond that.
After Joka. After
Joka, yes. Little beyond that on the right side, as you go from here to Diamond Harbour. That facility, what they say is, will be like people with autism, along with their parents, can move in. And after the lifetime of their parents, the people will stay for life.
Oh, that's a very.
And this entire project is done by a very affluent businessman in Kolkata. So now they have trained these children. When you showed this pictures, it immediately struck me. Those boys and girls are so good, and they have traveled throughout the country, made performances, musical performances. Some are excellent in computer skills. They can take classes. They have taken them abroad also, to Dubai, for the Middle East. And that person incidentally happens to be my relative. He is a very top chartered accountant. He left his lucrative practice and employment in Dubai, and they have settled in Calcutta. They are in Baligan Circular Road. So I have asked them to invite him as one of the speakers. See how actually the normal person should be able to, you need to be counseled. How do you treat the kith and kin or the parents of a person, a child, an autistic child? Autistic child, there will be doctors, analysts, psychologists, psychiatrists, but the family. So
how to handle these?
So he will become a quarrelsome employee. There's so much of pressure in his mind. When he goes to his employment, he will become very quarrelsome, fight with his manager, etc. The mother will not eat properly, keep starving. So I don't know whether tomorrow's program is there. You make a proposal. So the next event when they conduct, they will include you as a panelist, madam as a panelist.
So the main problem with DMD
Come forward.
DMD mothers, like for example me, I am the carrier. Okay, and once the child is diagnosed, the doctor will just tell bluntly that this disease comes from the mother. And what happens, what I have followed, like there are many carriers, like carrier mothers of DMD like me, and most of the mothers are being blamed not only by their families but also the people who know them, because they say, it's coming from you only, you are to be blamed. And once this diagnosis is disclosed to the parents or the families about the mother being the carrier, everything changes within a second, because the husband and wife relationship also ends, because somehow the husband is, everybody knows that she is not to be blamed, but when there is some fight or something is not in the properly functioning in the family, the whole thing is ghoom ke, it comes on the mother only.
But
So
how do the doctors say it is only due to the mother?
yes, because it's an X-linked disease. So I am a woman, so I have two X, so I became a woman. One of my X is defective. That's why I have chromosome is defective. So I have this, this defective chromosome is passed down to my son, and they are getting Y from their father. So this is how the DMD Duchenne muscular dystrophy
Anybody
happens.
from your family had this?
Yes, it's from my mother's side. I got it. Like for my brother got my mother's good X, but I became the carrier. I got the defective X from my mother and the good X from my father.
But can this not be deducted at an early?
That is a very requirement that at the initial stages there should be some medical at the time
Most of the mothers are depression.
That's NPRD 2021 version. There were steps taken nowadays detect such cases at the prenatal stage only.
Yes, that is very important.
Then what needs to be done is,
Like most of the mothers are goes through depression because of this problem, because
no, the screening, in fact, one
That's-
PIL,
this is newborn screening or
one PIL came
prenatal screening.
where they said that door-to-door screening, some of the parameters has been removed. ASG also appeared in that matter.
Those NPRD 2021,
Ah.
those stipulates the initiatives which are to be taken and the steps which are need to be taken at a 10
See,
years or 15 years
The
down the line.
problem lies is they should disclose. Suppose they come to your house, you're a small baby. Your mother or your parents should disclose that in our family, this
Lordship,
problem
they were not even aware.
My parents
The point is that now, when science is so much more advanced, at the prenatal stage, this should be one of the compulsory tests that is
compulsory test.
because many of the parents do not even know what.
Is it possible? Prenatal.
Now we are doing at-risk cases and it is freely available at SSKM hospital. Sir, from SMA, the prevalence is much higher. So there are some countries they have started in abroad for routine screening for SMA, but not for DMD. But carrier testing must be done for all cases where the family history is positive. Sir, it may not be possible to screen all in community, but definitely, sir, family screening and family counseling is absolutely essential for all these neuromuscular disorders.
I want to make it compulsory like SMA, since muscular dystrophy is frequent more than SMA. DMD, Duchenne's muscular dystrophy, is more common than SMA.
Then
So it
probably
should
your
also
society
be
can-
mandatory for DMD
Your
screening.
society can organize a small consultation or workshop.
We try to do that. I specifically do that because most of the doctors in Kolkata, when they diagnose a new case, they probably move forward that to me, and I try to counsel the parents as much as I possible. Also try to help them or navigate the treatments so that they doesn't feel helpless. What I have been gone through when my sons were diagnosed.
In fact, she came to know about the disease when her son
Yes,
was
because
diagnosed. Before that,
I
there was
wasn't
no
even
idea. Her parents
about-
were unaware, and so was she.
And most of the families are unaware of this thing, and there are many situations or instances where, like for me it's genetic, but there are also cases where it is a spontaneous mutation, where there is no family history of muscular dystrophy, still the child has muscular dystrophy. But same with the same thing, but it again comes from the mother's side, that doctors can guide more.
So we will be requesting, I would like to meet Professor Mukherjee, and if this prenatal test can be made compulsory, we would, that's a very big effort, but if, because a very limited number of patients come to SSKM hospital. It's many other hospitals in the state that are also affected. So there has to be a government circular to that extent that this test has to be done. Otherwise, many families would be saved. Lordship, we will not trouble your lordship anymore.
DMD. What in the other one? What is it? SM.
SMS.
Spinal muscular atrophy.
SMA. It's another rare disease, another kind of rare disease.
Spinal?
Spinal muscular atrophy, SMA.
Sir, please come. One other issue which has been flagged is with regard to compulsory prenatal scanning for detecting DMD, which is one of the rare diseases. It is submitted that such screening is available for SMA, which is also one of a rare disease. But definite protocols have not been put in place so far as prenatal scanning for DMD. The state can explore possibilities. The state can explore possibilities of extending this screening, which is now being done for SMA, to cases to enable early detection of DMD cases. The appropriate authority of the government shall examine this aspect and place their viewpoints in the form of a report. Let us see on Monday what happens.
Lordship, one humble request. May the order be uploaded today. Will it be possible?
Yes, 100%. We don't delay, they don't delay, we don't delay. Everything will be uploaded. Even if it is judgment reserved, delivered, within 1 hour after our signature will be uploaded. Day before yesterday, 55 page judgment uploaded.
We are very grateful to your lordships.
Thank you, madam.
Serial number 4.
All right, not today.
Serial number 5.
Your Lordship, I am appearing for the respondent in serial number 4.
That Murshidabad Lordship has already dictated the detailed order. After hearing,
Serial 4, not today.
No, item number 4 is one refund matter. Last 3 occasion,
We are waiting for your
the state of.
See, the tribunal's order is very reasonable.
The only thing that I have seen a ground,
Item 4.
that they could not show any documents as regard to the dispatch.
Assuming we allow your writ petition and send it back. We are in 2025. 2017, 16, 17, 18, you ask them to produce. Contemporaries documents are there. Like in cases of defective C form, what does it say? Supreme Court says, don't go by that. If there is a defective C form, you see the other contemporaneous documents and then take a decision. Ashok Leyland judgment.
This education will be missing from Monday. That's why I said a single sentence. This education will be missing from Monday, my lord.
That's how you approach a problem. Even when the department comes to you, that's how you approach the problem. Banerjee succeeded the day before yesterday.
Yes, my lord, he has sent me the judgment. He has sent me the judgment.
Let us, they will take it up. Agarwal will take it up on appeal to Supreme Court. Let us see what happens. But what made it easier was the tribunal committed a mistake saying that assessee need not file an application for refund. That Agarwal himself knew that is wholly incorrect. So he didn't make much submission on that. He said, my lord, my lord, my lord. But that hit the point. Because how the officer, it's not his pocket money, no, to take it and give it out. Even then, theory of unjust enrichment could have been applied. Possibilities. So there are no vested right. There is a right to apply, but no vested right to get a refund.
Absolutely.
This writ petition has been filed with the state, challenging the order passed by the West Bengal Taxation Tribunal
60 days ago, the order na pass karle refer de deta.
in case number RN 146/2011, dated 18/11/2011. The respondent herein filed the application before the learned tribunal, challenging the order of assessment whereby input tax credit was disallowed. The respondent is a manufacturer of leather goods. By purchasing finished leather from registered dealers in the state of West Bengal, and the entire goods so manufactured are meant for export. This factual position has not been disputed with the department. During the period covering 4 quarters ending 31/3/2008, the respondent filed their returns under the provisions of the West Bengal Value Added Tax Act 2003, within bracket the Act, declaring its gross turnover at rupees 10,48,77,480. As full stop. As noted above, the goods manufactured for was exclusively meant for export, as a result of which no output tax was payable by the respondent. The sales tax officer Bhavanipur charge initiated assessment proceedings, and in the same and the said proceedings, the respondent claimed refund of the amount under section 61 of the Act, read with rule 76 of the WB VAT rules 2005. The sales tax officer accepted part of the claim of input tax credit to the tune of rupees 25,67,511 and the remaining rupees 2,52,455.35 was rejected on the ground that the respondent had purchased goods worth rupees 75,959 from Messrs. Akram Leather Corporation, and the entire claim of input tax credit was liable to be rejected. The learned tribunal found no. Upon verification, it was found that the respondent had actually purchased goods worth rupees 60,247,42 from the said supplier. And in view of the wrong figures and statements submitted by the respondent, the input tax credit was disallowed. This action of the department was put to challenge by the respondent. And statement of accounts were also furnished, were placed for consideration of the learned tribunal. It was argued that the claim for input tax credit has not been verified and reasonable time has been sought for the purpose of verification. The learned tribunal noted that the claim made by the respondent for input tax credit is on account of the view that the goods were manufactured for the purpose of export, which factual position was not challenged by the department. The tribunal noted that the respondent had placed several documents to establish their stand with regard to the value of the goods purchased from the said supplier during the period from 1/4/2007 to 31/3/2008, and the department had sufficient material to cause verification. However, without doing so, the department came up with another plea that the amount of rupees 5,27,990 is not sustainable, as the respondent herein did not submit documents regarding dispatch. The tribunal noted, in our view rightly, that the transactions were done several years back, and the respondent herein had come up with positive statements that the sellers in their respective returns have confirmed the factum of sale of goods to the respondent, and the respective sellers have filed returns indicating the sale, which has not been rebutted or disputed by the department at any point of time. Therefore, the learned tribunal came to the conclusion that it is not fair on the part of the department to call upon the respondent herein for production of evidence of dispatch after a long lapse of time. Thus, being satisfied that there was evidence regarding the supply of goods to the respondent herein, which was borne out in the returns submitted by the respective sellers, the tribunal concluded that the input tax credit claimed by the respondent herein cannot be rejected. It appears that the tribunal granted sufficient time to the department to respond by bringing a positive statement as to whether the claim of rupees 7,41,486 by way of input tax credit is sustainable. However, the learned tribunal did not respond to the opportunity granted by the learned tribunal. Therefore, the tribunal concluded, rightly, that there was no justification for withholding the balance amount of rupees 12, 69, 477. Thus, we find that the tribunal, after having carefully analyzed the documents placed on record and also the various opportunities granted to the department, which were not utilized by the department, and more importantly, the fact that all the goods which were manufactured from the raw material purchase were meant for export, and rightly granted the relief as sought for by the respondent before the learned tribunal. Thus, we find no grounds to interfere with the impugned order. Accordingly, the writ petition fails, is dismissed.
Grateful, my lord. Grateful, man.
Serial number 5.
You give the pipe.
তুমি ফেললে?
না না আমার হাত যাবে না। যদি লাগে আমি তাই জন্য one notification.
Mr. They and Mr. Bhonjo were submitting on behalf of the department.
But the question is, first of all, on going through, we found there's no material to support the stand that there was suppression with an intent to evade payment of tax. Secondly, who is the central tax authority to sit in judgment over a state government notification? They know what has to be done, what is the value addition to be made, and how much they will pay per bag or per kg hulling.
Yes, my lord. Their allegation is that the value of the bag for which the state government has paid at a particular price, that they say that this is under, my lord, that should be the cost price which they have investigated on their own from various sources. We don't know from what source they have come to know that the price which the state government is paying.
Where is Mr. Kaushik Dey?
Well, he is arguing a matter, my lord. Both Mr. Dey and Mr. Bhonjo.
But that section 74 is the only issue, my lord. All the mill
He is not there, no?
And
suppose assuming you were arguing here and he was here in your position.
Learned AG is also there.
AG is also here. We are thankful to you.
Keep it on the Monday.
Let us see if possible.
Yes, please.
No, I don't have any problem, Lord.
Because I promised to come back to the chamber at 1. A lot of people are waiting. That AG was, have you gone through the order dated 5th of August?
Yes. Of your lordships. Yes, I've gone through.
You just go through it.
Yes.
That's the only scope. And only 2 issues arise. And he has given up the prayer for challenging that notification.
Right. That has also been recorded.
That we have recorded, dismissed that prayer.
Yes.
Here also they put so much of annexures, no? You give that paper. I think one paper mill you can take on lease and rename it as Vinay Sharaf Paper Mills and Products Private Limited.
What to do, my lord? Whatever document. If this is emanating from the order, they file the detailed reply. I cannot, my lord, avoid including the, my lord, annexure.
What you do is tomorrow you make show cause notice, reply, order.
Yes.
Only one set. Send soft copy to madam. She will give it to AG.
I understand, my lord, but it is not my fault, my lord. If they enclose the various documents, my lord, I cannot avoid them.
This is ladyship set. All right, we will not look into this. You make one set. No, I think it is mixed up.
Yes.
One set is mine.
Well, what happens is that your lordship is can appreciate all the facts from the reply without looking at the annexure. But if we don't enclose, then we may be allege that I'm trying to suppress the document, not bringing it to
That
record.
they will allege. What you do is, that is why in other high courts, they make a convenience set.
Yes.
Which will contain, because this will be on record, has to be on record. Because suppose suddenly they refer to one annexure, we have to look into it. In fact, the other day we did on Indian oil matter, IOCL, no? Mr. Kundu appeared, Devashish Kundu, writ petition. There also we requested a convenience set. So 5-7 volumes of irrelevant documents. But he had to, Mr. Kundu had to refer to 1 or 2 of those documents in the annexure.
Correct. But the problem is that if they file a detailed reply with all the details, annexure, documents and all that, and we just include the reply without those annexure, then the department may say that you have come up before the court, you are not enclosing the...
Does anybody certify that the annexures are true?
Yes, my lord.
Does anybody certify that the annexures...
That too, in the affidavit itself, it is certified, my lord, that whatever statement I am making, they are true. And so that
it is the responsibility of the advocate on record.
And my lord, the person who is executing the affidavit also, my
lord. I tender my apologies, lordship. You come from court number 15.
No problem. And what do you say with regard to suppression? 2 issues only, sir. Suppression, there is no material. Secondly, central tax officer, how does he sit in judgment over a state government notification? Sir, he is bound. We have gone through the concerned rule where several conditions are there. Yeah, it's not like, and he is not to accept any private hulling during the period when he is registered. And the entire paddy or whatever it is supplied, wheat is supplied for public distribution system. So they have made a guideline. So you make some roving inquiry here and there, and how do you say he suppressed? He followed their guidelines.
The guideline was for purpose of productions or for the purpose of further processing. But so far the GST is concerned, lordship, there is suppression which I will try to show to your lordship.
Volume 1.
If your lordship kindly comes to page 535.
535, it should be volume 3. 4.
535 is volume 3, my lord.
Yes.
If your lordship kindly takes page 555, the serial number 12. Now lordship kindly sees subpara 1. It has been clearly stated why, my lord, this we have
as the tax liability has not been deposited self-funded, the provisions of so and so are invoked.
It is the section that has been quoted. Now the main finding is at page 538. But in the middle portion. But in the instant case, the taxpayer had cognizance of the fact that non-monetary consideration rupees 43 in the form of 2 gunny bags and rupees 81 in the form of bran and refraction are involved in the total consideration received from FNSD after issuance of memo number such and such. Again, being involved in the milling business, they are also aware of the fact that during manufacturing process, refractors and bran are come out as byproducts, which have a certain sellable value in market. Hence, in no way they can escape from the responsibility of assessing the value of the taxable supply as well as liability of tax as registered taxpayer. So, in view of above, section 74(1) is very much invocable in the instant case.
No, where is the allegation of willful misstatement, suppression of fact, or contravention of the provisions of the
Or these are the allegations, Lordship. These are the allegations because he has not disclosed these facts. In spite of being a person of this trade, he ought to have disclosed all these things, which he has not done.
But you are aware of the entire facts. You have you also invoked the extended period. For invoking the extended, and the show cause notice itself, the basis is from his own documents.
Well, it kindly, if your lordship sees the key dispute, which in the order they themselves have framed on page 134. Page 134, my lord, volume 1. The key dispute which the concerned authority in the order in original is framed, my lord. The key dispute framed by the authority, my lord. That is not the dispute which my learned friend is referring to. That is not the dispute at all. But kindly refer to the key dispute, my lord.
No. That is one of
the query of the court, Miller, there is a finding at page 145A.
Lordship kindly comes to page 144.
Sir,
the
kindly
middle
allow
portion,
me to submit one.
paragraph
Let us,
18.14.
sir, kindly have a look at the key
There's a
dispute,
definite
134.
finding to this effect. There's a definite finding to this effect.
18.21.
Paragraph 18.14. Middle portion, page 144.
So they say it's not a fit case of prosecution.
But kindly refer to the key dispute framed in page 134.
Yes. Please come to page 134, para 18.8. Our question is whether you can do this.
This is the dispute, my lord, not the dispute.
See whether the contractual agreed value of goods rupees 60 as per the agreement between the noticee and the Food and Supplies Department can be considered the actual value of the goods supplied with a composite value at 260.48. This is as per a notification issued by the state government. Unless and until you say that fraud has been committed in the notification itself, you cannot examine this aspect. If he has done some mischief, keeping the notification of the state intact, assessee has done some mischief, saying that this should have been the actual, but you have done this, therefore we are invoking this provision. That's a different case. Can you doubt this? Is what so if you doubt this and a finding is recorded, you make their notification nugatory. It cannot be implemented.
Well, kindly refer
no,
to.
What is the basis on which they come to the conclusion that the value of the packaging material and nutrients are higher than the contractual value? That is your simple dispute. You say contractual value 60, all put together 260 point, how much is? 48.
Yes, my lord.
This is, you say it's incorrect. But that's what is being paid to him by the government.
And apart from that, one of the non-monetary consideration of rupees 43 in the form of 2 gunny bags and 81 from the brand and reflection.
Their investigation is on page 108, my lord. 108, my lord, kindly have a look at the investigation regarding the value of.
And there is a finding to this effect also at page 1.
Paragraph 6.4, my lord. Page 108. That is their investigation about the value of goods of the my lord, this packing material and fortification. That is the dispute, my lord. Whether that value of fortification material and the packing, whether it exceeds 60 rupees or whether if it is 60 rupees, then my lord, I am within the parameters of 3A, because the value of goods supplied should be less than 25%.
What is the material they had in hand to say that value?
That is what I am coming to, my lord. Kindly have a look at their my lord, the investigation, page 109, my lord. This is where from there, the my lord, 10. 9, my lord. This table C. Details of packing material as per invoices, statements of various millers.
Which paragraph?
109, my lord, kindly have a look at table C, 109.
A plus B.
Details of packing material. The heading says the details of packing material as per invoices, statement of various millers. So they have taken a state.
We don't get that.
108, my lord.
No, it's a 109.
109, sorry, 109.
109, table C.
Correct.
Table C.
Table C. On the
Details of
heading,
packing
they say
yes.
details of packing material as per invoices, statement of various millers. So they have done their own investigation. Then, my lord, after doing the investigation, my lord, kindly see the total cost C plus D, 103 to 121, 81 to 91. Then, my lord, they say that on comparative study of memo dated so-and-so issued by the FNSD Department Government of West Bengal, wherein the estimated cost of goods, packing materials and prefixed vitamins involved in the composite supply is derived at ₹60. The percentage of consumption of goods over the composite supplies arrives at 23.03. Whereas as per DGGI's headquarters investigation, considering the range of consumption of the goods as per 81 to 123 percentage comes at over 25%. This is the dispute. So they do investigation.
No. Did they supply you the copies of the investigation report? What are the material there?
No, this is all they have supplied. This table is all they have supplied.
No, they say para 6.5, page 110. Therefore, from the evidence gathered,
those evidence they have not supplied to me. In the so-called notice, this is the table which has been reproduced, my lord.
Where are your grounds in the writ petition?
My grounds, my lord.
On what ground your writ petition was dismissed?
My lord, it was, my lord, we had already paid 5.5 crore rupees. During the investigation, they called us to Delhi. There was a office of DGGI in Calcutta also, but they called us to Delhi and forced us to make payment of 5.5 crore rupees. Total amount of dispute is 8.8. So, my lord, we were not given any stay by the learned single judge. That is why, my lord, we have approached your lordship. That we did not get the stay.
Against refusal of interim order, you have...
Interim order, correct.
Where is the order, impugned order?
My lord, that interim order, impugned order is on... my lord,
you give memo of appeal is there?
With the memo of appeal, my lord. It is there with the memo of appeal.
This one, no? Then where is the proof to show that you have paid 5 points?
I will show.
So 50% of the demand has already been
more than 50%, my lord.
Then you do one thing. We have recorded that the challenge to the declaration relief is not pressed. That once again we will record. We will record that more than 50% has already been recovered, which according to the appellant is under the threat and coercion.
Or we dispute that, lordship.
Which is being disputed by the department.
No, my lord, it is recorded in the order itself. Order in original itself records that I have paid 5.5 crore, my lord.
No, I'm disputing regarding the coercion and pressure.
Page 209 is my details, my lord. With the challans, my lord. 209. I have enclosed the, my lord, this DRC 03 challans also.
Which volumes are?
But this is in volume 2, my lord.
So 210.
Where is the order in original?
My lord, the order in original is on page
102.
The
102 onwards.
Computation, last page.
Yes, the last page is
My lord, the last page.
145.
145A.
Total demand is 8 crore
73 lakh 86,000.
More than 50%, sir. So we will grant a stay. You file your affidavit with regard to these issues.
My lord,
writ petition will be heard.
My lord, what I request, my lord, this 5.5 crore, my lord, is stuck for 4 years.
We will treat it as a deposit. Pending adjudication. Prior to adjudication, this amount has been collected. You are raising an issue saying that you are compelled to pay.
Yes.
They are disputing that compulsion. So for the present, till the court adjudicates on that point, the payment or recovery made from the petitioner shall be treated as a deposit.
My lord, your lordship's order is.
And all we can't grant, sir. Sir, let us be practical, Mr. Shroff.
My lord, my lord, I'll just point out, my lord, your lordship may. Your lordship.
Every case you file can't go in the same direction as you have decided while dictating the grounds.
No.
Then why are we here?
No. What I'm saying, your lordship has decided, my lord, previously that if during this investigation, date of investigation, my lord.
This intra-court appeal has been filed by the writ petitioner challenging the order passed by the learned single bench in WPA 8713 of 2025, dated 25/6/2025, by which the learned single bench declined to grant any interim order / interim protection, but directed the respondent departments to file their affidavit in opposition within a time frame, and also granted liberty to the appellant writ petitioner to file a reply. And agreed by the appellant would contend that during the course of investigation, the appellant was directed to appear before the investigating authorities, namely DGCI, DGCE, DGGI.
Yes, ma'am.
GI at New Delhi.
Yes, ma'am.
And they cooperated in the inquiry, and a sum of rupees 5,50,62,464.00 was compelled to be paid by the appellant, which was remitted, and in proof of such remittance, the details of payment made through DRC 03 on 3/12/2020 has been placed before this court in annexure P8. We have heard this matter on earlier occasions, and for the sake of convenience, we have capsulized the issue which would fall for consideration in the writ petition. For easy reference, we quote the order dated 5/8. We quote the relevant paragraphs of our order dated 5/8/2025. Para 3, from para 3 to till the end. Para 16. The learned advocate appearing for the CGST authorities would dispute the contention raised by the learned advocate for the appellant that the appellant was compelled to pay the sum of rupees more than 5.50 crores, but it is a payment made by them. This issue needs to be adjudicated, for which affidavit has to be filed. The total demand of CGST and SGST is rupee 8,73,86,825, and the sum of rupees 50,60,464 has been appropriated as against the said demand, and the balance amount of rupees so on. And apart from that, in the order of adjudication, penalty has been imposed under section 74 within bracket 9, read with section 74 within bracket 1 of the Act. In the preceding paragraph, we have noted the broad issues which fall for consideration in this appeal. in the writ petition, which needs to be adjudicated, after affidavits are exchanged in the writ petition. We make it clear that to adjudicate the aforementioned issues, disputed questions of fact need not be gone into. Full stop. That apart, when this appeal was heard on 26/8/2025, the learned advocate appearing for the appellant on instructions submitted that they are giving up one of the prayers, which was for a declaratory relief. And recording the said submission, we passed the order dated 26/8/2025, and the relevant paragraphs reads as follows. Para 2. In the light of the fact that the appellant writ petitioner has paid rupees 5, 50, 62, 464, which according to the appellant was compelled to be paid, which stand is being vehemently disputed by the CGST authorities, till the writ petition is heard and decided, the said amount which has been paid by the petitioner shall be treated as a deposit and shall abide by the final orders that may be passed in the writ petition. Full stop. In the light of the fact that more than 50% of the demand has already been recovered from the petitioner, the interest of the revenue stands sufficiently safeguarded. Full stop. Even assuming an appeal had to be preferred against the impugned adjudication order, the appellant would be required to deposit only 10% of the disputed tax. Therefore, this is also one more reason to treat the payment of more than rupees 5.50 crores as a deposit till the writ petition is heard and disposed of. Till the writ petition is heard and disposed of, no further amount shall be recovered from the appellant, and the balance demand, as mentioned in the order in original dated 23/1/2025, shall remain stay.
But they will be filing here. But
No, the appeal stands disposed of. The time for filing the affidavit in opposition and reply stands extended by 4 weeks from date. Let the writ petition be listed before the appropriate bench in the daily list on 20th November.
Great.
We'll stop with this.
Grateful to your lordship. Probably my last matter before my lord.
Best wishes, my love.
Thank you.
My best wishes. But just your lordship, it gives me 1 minute. I just want to say something. But I think because of your lordship encouragement, a lot of juniors practicing here,
they are all the future of this court.
They become counsel. I'm one such junior, Himanshu is there. So I mean,
He's here.
There are others also. I cannot name all of them. But myself, my lord, I've been beneficiary because, my lord, I came into the profession 10 years back. Being a chartered accountant, I practiced earlier. So I did not have the opportunity of having a senior. I myself tried to figure out.
That's the problem with you. Suddenly you will start arguing as if you are arguing before income tax officer.
So that's
before the commissioner appeal. Forgetting there you are before a high court.
That is the problem, I know. So, but because of your lordship encouragement, I'm trying to improve and trying to find my feet before your lordship and in the court. No, that is not my fault. I mean, you may make it because if the replies are filed by the detailed replies, so I cannot
reply to everything.
I have not seen any of this petition less than 600.
100%. You're right.
Oh, that's good. That's good for the stenographer and the.
Correct.
Again, good for the revenue.
Oh, live and let live principle. So let them also be benefited. Paper vendor will be benefited. Clerk will be benefited. Stitching
but
fellow
my lord, if the those papers are filed before the officer. We have to
Most of the papers which are filed are illegible. And I think it is high time we give up the rule regarding informal paper book. It makes the thing more bulky. Secondly, you are asking him to type out an invoice. And these typists will definitely miss 10. The registration number of the vehicle will be something else. And they will make out a case on that. You will not have time to verify the original. How many of you verify whether the typed content is exactly the replica of the original? You can't. So if at all you have to file an informal paper book, you can scan those documents and do it. Tribunal passes a 10-page order. When you type it out with this much margin, this much line spacing, it is almost 35, 40 pages, becomes so boring to read. Instead, you scan the paper, it is available online, download it, then you can file. But I think by and large, this is the clumsiest filing in the whole of the country.
I remember Justice Keshavani also said the same thing.
Very difficult, sir. Nobody told me before I came here. See, without your assistance in the stay petition, we cannot find out the page number. Secondly, what they do in the appeal, they have these annexures papers, then put up the writ petition annexures behind it.
Yes.
So there is a duplication. Each set contains 2 sets. Anyway.
No, probably there is a reason for that, my lord, because earlier we had this concept of unlisted applications. So pursuant to that, the paper books used to be filed. Paper books consisted of all the documents, which is why, my lord, probably that hegemony system continued, and somehow it couldn't marry properly to the present system. Advanced digitized system. Probably now things will change slowly.
AG can make suggestion. Thank you very much.
I'm grateful to your lordship.